As you mentioned at the end of the day yesterday, on February 10th, 2016, United States Federal District Court Judge Leroy granted summary judgment in favor of the City of Macedonia and all the named defendants in the Farnhurst and Plot case. The court granted summary judgment against Farnhurst and Plot on all issues set forth in their complaint. That was filed in March 2013 and it was amended subsequently in 2014. Summary judgment is relatively unusual because it happens before a trial takes place and essentially means that the plaintiffs failed to provide any evidence whatsoever supporting their allegations. It's noteworthy to point out, and this is right in the judge's decision, so I encourage everyone, I'm giving a summary now. It's available for free on the court's website. You can go look at it. I encourage everybody to read it and make their own conclusions. But it's noteworthy to say that the only evidence plaintiffs could point to were an isolated statement by Councilperson Hannigan about remarks made by officials behind closed doors. And she concluded they were actions of the city and had something to do with denial of permits. The court found this to be less than a scintilla of evidence, which means something very insignificant, and that there was no corroboration, no one else suggested anything similar, and that such remarks, even if true, were inconsequential to the federal lawsuit. So now the next step in this process is the caveat that I mentioned earlier. The court will finalize its journal entry. This will happen on or about February 16th if the parties don't exercise the option the judge provided to attempt to settle the case before that point in time. At which point in time, all defendants will have the opportunity to request reimbursement for the attorney's fees and costs incurred in the litigation. This next portion, the Law Director Deemer, former Law Director Deemer, specifically asked me to include. He would like to remind counsel that he's repeatedly advised them in executive session and publicly since 2013 that this was a bogus lawsuit. He predicted this very outcome. 1 year after the lawsuit started, the Plot's named Mr. Deemer and Mr. Hansluck as defendants in the case in an attempt to neutralize their legal abilities, and Councilperson Hannigan's political arguments against the administration was the purpose thereof. It is now evident from the judge's ruling that there is no basis whatsoever for Mr. Deemer or Hansluck being named as defendants, other than certain individuals' personal agendas. The law department, particularly Mr. Deemer, is obviously extremely pleased with the outcome in favor of the citizens and the taxpayers of the city. It's really an unfortunate situation that the process was used in an attempt to demean the public servants who, I think the vast majority of citizens realize they're doing the best that they can for the city and do all they can on a daily basis for the city. Each of these servants have been vindicated by the decision, and they are each owed an apology by any person or official who doubted their integrity. The citizens are entitled to reimbursement of all taxpayer dollars that were needlessly spent in defense of this matter, and we will pursue reimbursement of those dollars by the plaintiffs and their attorneys.